Hello, everyone, and welcome to Season 3, Episode 2 of ARBinBRIEF. My name is Ibukunoluwa Owa, and I'm an independent arbitration lawyer based in Lagos, Nigeria. I'm part of the ARBinBRIEF team, and I'm very happy to be moderating the session today. A few words about ARBinBRIEF. ARBinBRIEF is a practical video guide on handpicked arbitration issues, showcasing talented and diverse arbitrators in an interview format. Now, in today's episode, we'll be discussing the topic for attorneys' eyes-only orders and the delicate responsibility that the tribunal has to balance competing interests when considering these orders and requests, and also the possible post-award issues that may arise from the grant of these orders. Now, our brilliant speakers today are Alessa, who is a partner at Wong Partnership in Singapore, and Dharshini Prasad, who is a counsel with 𝗔𝗥𝗕𝗏𝗏 in London. Thank you so much, Dharshini and Alessa, for joining us today. We look forward to your insightful contributions on this interesting topic. Now we'll proceed with the discussion. Hi, Alessa. Can you please explain what attorneys' eye-only orders are and when in the arbitration process parties typically request for these orders?
So just starting with what they are, an attorney's eyes-only order, as the name suggests, it's sometimes called an AO order. It designates a more sensitive level of information that can only be viewed by a party's lawyers and not by a party or the party's representatives. So it's restrictive in nature, and it means that documents which have been designated subject to the AO order can only be disclosed to the lawyers. And if you wish to disclose it to the clients and sometimes even experts, it would require the prior consent of the counsel for the producing party. So we see it being used in commercial arbitration, and it's sometimes also used in investor state arbitration proceedings. It's useful if an opposing party is a competitor and the documents contain commercially or technically sensitive information which you don't want a competitor to have access to. Although the competing interest is that a party against whom the order has been made would be concerned about the effect it can have on case preparation, because sometimes clients can provide very valuable input on documents which are disclosed in the course of arbitration proceedings. As to when such requests, the request for such an order are made, it would depend on the procedure adopted in the arbitration. So sometimes if you see memorial style pleadings adopted in arbitration, that's the first point at which documents would be produced. And if there are documents that a party is concerned about producing at that point of time, they may apply for the order earlier in the arbitration. Otherwise, it is likely to be around or at the same time that the document disclosure process takes place.
All right. Thank you very much for that explanation, Alessa. So now that we know what attorneys' eyes-only orders are and what stage in the arbitration process parties typically request for it, Dharshini, can you please explain what generally are the factors and competing interests that tribunals have to take into account when considering this sort of request?
Sure. I think one thing to remember when you're talking about either attorneys' eyes-only orders or protective orders more generally, confidentiality orders more generally, is you've probably crossed the stage where a tribunal or a party, by including documents in a submission, has agreed or that the documents are in fact relevant and material to a case. So for instance, if you're in the universe of the IBA rules, the tribunal has typically already decided that not only are they relevant and material, but it's also overcome any potential objections to disclosure on the basis that there's a sort of compelling commercial or technical sensitivity to withhold disclosure. And so I think when you think about that in that framework where you're talking about not just evidence that's tangentially important, but evidence that could be relevant and material to the outcome of the case, it really crystallizes where the tensions are. And the core issue, as Alessa said, really is how do you balance the sort of legitimate interest of a disclosing party in wanting to protect its commercially or technically sensitive data with essentially the right of the receiving party to a fair trial. And that's a few things. One, it's the ability to review and analyze evidence to provide instructions. That includes just, from a common law perspective in particular, it's quite important that parties know the case they have to meet and the evidence on which that case rests. And more broadly, it's about clients being able to both understand the advice that they're being given by counsel and also the grounds for a judgment that eventually comes out. And so it really is a quite sensitive balancing analysis. Courts have done this many times. Tribunals are increasingly having to do it as well. But the thing to remember is within that broad sort of framework, and I'll walk you through some tests that exist, but within that broad framework, the reality is it's a very fact-sensitive analysis. So you're going to have to ask yourself in every single case, what is the data you're looking at? What is the nature of the parties' relationship? What sort of measures can be taken to protect the interests without over-infringing on a party's sort of due process rights? And of course, we all know that due process rights are not absolute. It's it has to be calibrated to the facts of the specific scenario. So there is a lot of case law, particularly, I think, in common law jurisdictions where there is more of a tradition of disclosure and the sort of production of evidence. And largely that stems in the IP and competition context, although a lot of those principles have also been applied in the commercial context. And in fact, one of the leading cases in the UK, I've actually had to address and rely on in a non-IP commercial arbitration, which I'll get to in a moment. So I'll maybe just use the UK as a starting position. And I think given the interest of time, I probably won't be able to go into some others, but we can touch on it in questions. So the UK position is fundamentally that confidentiality in itself is not a bar to disclosure. And more importantly, confidentiality restrictions, whether a highly confidential attorney's eyes only designation or some other form of restrictive club, is really the exception rather than the rule. And that's precisely for the tension we sort of talked about earlier. And I think the leading case on this today came out in 2020, and it was a Court of Appeal decision in OnePlus Technology and Mitsubishi Electric. And the court quite helpfully goes through a quite long list of authorities, and it draws out what it calls non-exhaustive factors that a court, or in our case, a tribunal, should think about when they want to order these highly restrictive measures. And just sort of very broadly speaking, the elements are, one, you always have to bear in mind that you need to balance the interests of the receiving party against the interests of the disclosing party. And the interest of the receiving party is that it should have the fullest possible access to documents. The second thing to think about is it is exceptionally rare, as the court said, to have no access at all, for a client or an officer or an employee of a client to have no access at all to evidence. There is no sort of standard form, and this goes back to the point about it being fact sensitive. Again, even if it's externalized only, that would be quite exceptional. Very importantly, the onus remains on the disclosing party to demonstrate why it is that these restrictions are required, because the starting premise in arbitration, as in litigation where you have disclosure, is that the evidence that you produce in a litigation cannot be used for a collateral purpose. So you have to show why that sort of base level safeguard is insufficient. Also, different types of evidence may require different degrees of protection. So a trade secret, for instance, might be likened to greater protection than, say, a commercial license, which might, after a period of time, go quote unquote stale. Very important is also the ability to police misuse, the extent to which a party can be expected to contribute based on the document and the development of a case, the role that the documents play in the case. Obviously, the more significant and central the evidence, the less likely it will be that you'll be able to restrict sort of complete access. And quite crucially, I think the structure and organization of the receiving party. So if your client is an individual and that one individual is the only person who can give you instructions, you're in a quite different universe to when you're talking about a large corporate entity that might have in-house counsel, a commercial team, a technical team, and you can sort of segregate who can and cannot see this evidence. I mean, thankfully for us in arbitration, many of our clients do fit in that category. So you don't run into the question of screening off one person and then having no one to give you instructions. And then I think the court also cautions that you should be careful you should be careful and alive to the fact that there's a possibility of misuse when a party can over-designate documents as confidential. And again, when we come to it at the end, I'll give you some war stories on that. The US position is quite similar, so I won't go into that. Really, the presumption is of access, and you need to show why you shouldn't. And just as an FYI, there is also sort of an EU communication now in the context of competition, litigation, and follow-on claims that also sort of talks about the circumstances in which you can sort of levy confidentiality restrictions. And I will suggest that you take a look at that, because you can definitely tell how the common law, civil law tradition influences the factors, because one thing the EU looks at, which you don't hear about in the UK and the US context, is how burdensome and costly a system of protective orders can be.
All right. Thank you very much, Dharshini, for that overview and explanation on balancing the rights of the requesting party to confidentiality and the right of the receiving party to a fair hearing and access to documents to be able to present a full case, and the sort of various factors that, you know, the tribunal needs to consider when considering this request. That sort of goes into our next question, because based on sort of interest that the tribunal needs to consider, there may be possible issues that may arise after an AO order is granted by a tribunal. So Alessa, can you please shed some light on possible post-award and due process concerns that may arise from the grant of AO orders?
So I think a lot has been said about the possible effect of an AO order on a receiving party, because you end up in a situation where a client or client representatives do not have access to these documents. So one of the main concerns that come to mind is whether or not the party against whom, or receiving party, who then loses the arbitration, could then try to challenge the award on the basis that there's been a breach of natural justice, because there's been deprived of a full opportunity, to borrow the words of Article 18 of the model law, deprived of the full opportunity to present its case in the arbitration, because its case preparation process has slowed down, it's been made less effective, or it's just been hindered by the AO order. And we saw that this was the nub of the applicant's complaint in a Singapore case, China Machine New Energy Corporation and Jaguar Energy. So this was a setting aside application which went before the High Court and the Court of Appeal in Singapore. So I'll just talk very briefly about the facts which underlie this case. So the applicant, I will refer to this party as CMNC, applied to set aside the award, which arose out of ICC arbitration, which was seated in Singapore. And this dispute, it was a construction dispute, so very document heavy, as some of y'all would know. It involved a construction project for the construction of a power generation plant. And CMNC was the main contractor, Jaguar was the owner of the plant. And due to disputes about delays in the construction of the plant, Jaguar terminated the contract, and arbitration proceedings were commenced against CMNC, who were the respondent in the arbitration. So in the course of the arbitration, when Jaguar submitted its statement of case, it informed the tribunal that it was going to withhold the production of 13 documentary exhibits, which were referred to in the SOC, because they were concerned that CMNC would misuse the information contained in these exhibits. There were allegations that CMNC had engaged in a series of threatening actions against it and its contractors. And so Jaguar said, we're only going to disclose these exhibits on an AO basis, so that they will only be available to CMNC's external counsel and expert witnesses, but not to their employees. So Jaguar followed up with a formal application to ask for these 13 exhibits to be produced on an AO basis. And I'll just pause to note that some of these documents included post-termination contracts, project schedules, and reports, which related or identified the post-termination contractors, which Jaguar engaged after terminating the contract and basically getting contractors to take over the work that CMNC was doing previously. So the tribunal allowed the application for the AO order, and it did so by imposing a two-stage regime. So the first stage was the default position, which is that any material designated AO by Jaguar would be disclosed only to CMNC's external counsel and expert, but not to the employees. But the second stage is that CMNC was actually expressly entitled to apply to the tribunal for its employees to be given access to AO designated documents for the purposes of giving instructions to counsel. So there were certain criteria that they had to meet in order for such access to be granted. So very briefly, actually after about 3 weeks, less than a month after the AO regime was ordered by the tribunal, there was an application made to lift the regime, and then it was replaced with the disclosure regime where the sensitive information would be rejected instead. So what happened was that CMNC lost the arbitration, applied to set aside the award. And I'll just focus on the appeal, where CMNC's case was mainly that it was not accorded reasonable and equal due process. And one of the arguments specific to the AEO order was that CMNC argued it was unjustified, it operated unfairly, and that because of it, it suffered prejudice in its ability to prepare its response, particularly to Jaguar's claim for costs to complete the project after CMNC took over, after CMNC was terminated from the project. But the Court of Appeal didn't agree with did not allow the appeal. Very briefly, it took the view that the tribunal was justified in issuing the AEO order. It thought that Jaguar had provided sufficient basis and reasons for the order to be made. And the Court of Appeal took the view that the tribunal had struck a balance between the competing interests of the parties through the two-stage process. Because even though there was the default first stage one, where documents designated AEO were restricted only to CMNC's counsel, CMNC was entitled at stage 2 to actually apply to the tribunal for access for its employees to have access to these documents. And in any event, any unfairness or prejudice was eventually mitigated following the redaction ruling, which replaced the AEO order. And so this case, I think, is significant insofar as it highlights the potential consequence if an AEO order is applied, particularly if a party feels that the AEO order has been unfairly imposed without properly considering the competing interests, and it feels that its ability to prepare its case has been affected. But all of this, I think, as the CA judgment shows, is that if these competing interests are properly considered, a seat court is unlikely to intervene, as most national courts would in assessing any procedural decision made by a tribunal.
Thank you very much, Alessa. That's a very interesting case and really shows the careful work of the tribunal to balance competing interests and how they can do this by safeguarding the rights of the receiving party and also the requesting party. So now we'll move on to the final question of the day. Dharshini, can you please share some practical tips and potential pitfalls when considering the handling of requests for AEO orders?
So I think the biggest sort of point with my experience with these sorts of orders is you really need to try to have these sort of finalized as early as possible. I mean, sometimes you just may not know until the case develops whether or not there is going to be highly sensitive information, but a lot of the time, if you really think about it, you will have a good sense of where the issues are, what types of evidence you're going to need. And it's quite important, I think, to have these measures discussed and put in, say, a PO1, because the reality is disputes over confidentiality measures, and I use confidentiality measures rather than highly confidential AEO, because actually that's a very specific type of restrictive measures, but actually confidentiality measures can be of quite varying degree. And my experience of going back to the point is the disputes can really take up a lot of time. Not all of them are in bad faith. Some of them are sort of good faith fights. And of course, there is then the separate risk of how these confidentiality debates can really lead to proxy fights that can seriously disrupt proceedings. And unlike litigation, where your general timeline for things like disclosure and the case overall can be quite lengthy, with arbitration, we have fairly compressed timelines. So if you have a party that's at the stage of disclosure, trying to make arguments about measures and who should be allowed and on what grounds they should be allowed, it can really disrupt the timetable. And again, I've had to deal with that firsthand in at least one case. One other thing to think about is oftentimes the documents will come from the parties themselves, but sometimes the data they're having to provide will touch on the confidence rights of third parties. And in those scenarios, it might even be important to sort of get approvals from third parties. And again, that's something that I've had to deal with in one of my cases. Now, when you're thinking about what the protections are, I think that obviously the base threshold question is you need to figure out whether you even need these protections. That obviously turns on the nature of the dispute, the evidence you're likely to require, certain categories of data you already know will be likely to be contested. So pricing information, customer information, business plans, trade secrets, sensitive commercial contracts. And if you know that certain disputes just raise IP issues or raise competition issues, again, both of which I've had, you don't even need to know the specific categories. You can almost assume that you're going to need some sort of a restrictive regime in place. The second question is really what sort of protections are appropriate. Now, again, the attorney's eyes only is one option. That itself is a misnomer because it's very rare that it's only the attorneys that look at it, because at the very least you might have experts in as well. But I think it's sort of generally used as a term that's intended to exclude clients. But you should think about whether there's things you can do in addition to protective measures. So one thing I've seen in cases is the use of data rooms. So you essentially don't even give access to the document to the clients, for instance. The documents are produced, but we need to sort of set up a separate room where our witnesses or experts come and look at it. They can't take copies of it. There needs to be someone in the room, like a lawyer or an in-house counsel, monitoring the entire exercise. And again, these are just things it's worth thinking about at the outset, because all of those debates take up time if you're doing it once a timetable has been established. I think one big source of dispute is typically how documents are tagged. Now, in the US, sometimes you see that parties do blanket taggings. So they don't actually review, and this has to do with the scale of the disclosure you see in US litigation sometimes, but they don't individually look at documents and make a designation following each analysis of each document. It's typically everything is like presumptively tagged, which then sort of shifts the onus onto the receiving party, which is A, incredibly time intensive, and B, when you're looking at the sort of compressed timelines we have in arbitration, are incredibly challenging to navigate. So again, have had fights over these as well. And sometimes it's not realistic to expect a party to individually review documents and make individual determinations on tagging. So you can do things like meet and confers, where they do the blanket taggings, and then counsel, and again, this is a very US concept, you can then essentially get on a call and the lawyers try to thrash out what they can de-designate in either classes of documents or specific ones. And if you can't resolve that, then it goes to the tribunal, obviously. Which individuals should be admitted is also something to think about. And this is hugely contentious, typically because lawyers are never an issue. Experts may or may not be an issue, but clients are usually the big sort of sticking point. You might see scenarios where in-house counsel are involved, or at least the in-house counsel who give instructions, but there might be blanket restrictions on people in commercial teams and technical teams, depending on the type of data. So there's case law in England where even when they've allowed sort of commercial teams in, they have restrictions like if these people come in, then they can't take part in negotiations over a contract. But I think the ultimate challenge is how you police some of these things. And this is sort of the next point, which is, unlike in litigation, with arbitration, you have jurisdictional issues. So how do you, one, have undertakings provided by individuals in the club that can be policed once the tribunal becomes functus? And oftentimes these issues do arise once an arbitration ends. The risks are not so much limited to the case, but it's the time after the case is resolved. What do you do when you're dealing with non-parties? So, witnesses or consultants or even client representatives. I mean, it's only the client that's a party. So you need to sort of have language and undertakings in place that will adequately police all of the different stakeholders who might have access to the information. And just one brief point on experts. I sort of said they may or may not be sort of controversial. The reality is a lot of the times experts will operate in the same technical sphere as the parties themselves, which is why they're there to give you evidence. So parties may legitimately have concerns not just about the counterparty getting the data, but about an expert getting the data. And that was sort of the basis of a quite well-known dispute in the English courts involving Google and its sort of search engine algorithms. And there the court basically said, it was a motion to strike context, but the court said to Google, you either give the experts access to the information, even though there's a risk they might use it, or you are prevented from relying on that data in putting forward your case. But you can't affirmatively rely on evidence and then restrict a party from being able to get its experts to look at it and the party itself from looking at it. And the reality is an arbitral tribunal with due process, threat of sort of due process hanging over them isn't going to be as robust. I don't see a tribunal telling a party you either allow the other side to see it or you can't rely on the evidence. So I think, at least in the arbitration context, it might be useful to really think carefully about potential issues that arise even when you're trying to engage experts. If you can somehow avoid a potential conflict with the experts you engage, I think that might be ideal. Unavoidable in some cases, but ultimately ideal.
Thank you very much, Dharshini, for that detailed overview. I think you touched on a lot of interesting points and the sort of issues that may arise when you're considering this request, thinking about how to navigate through this request while still keeping the time efficiency of the proceedings and the type of protective measures that can arise, and how you can actually structure your request to know who would be allowed to see the documents and who will not be allowed, and the sort of issues that you need to consider. So it just really shows you how much there's so much to learn about this, and how this episode is not enough to cover the whole topic on protective measures. But I'm so grateful to Alessa and Dharshini for their invaluable insights, particularly giving us insights from US, the UK, and Singapore. And I encourage everyone to read more about it. It's a very interesting topic, and you may find yourself in a situation where you sort of have to consider it for your clients. So we thank you very much for this episode and your invaluable insight. We've now come to the end, and we would like to thank our partner organizations, ARBIPLEDGE and the Lagos Chamber of Commerce International Arbitration Center, for their invaluable support in making this episode possible. We also thank our other supporting organizations. And for those of you watching us over YouTube, our video ends here. Thank you so much for joining us. And to see future ARBINBRIEF episodes on handpicked arbitration issues, please follow us on our LinkedIn page, subscribe to our channel on YouTube. We look forward to hearing your comments and feedback, and you can register for the next episode at www.arbinbrief.com.